Mr. Lanto would like to, he's not going with any House counsel. He is wishing to represent himself. So today's the date and time set for the arraignment and pretrial. He is in prosecutor room 1.
Okay. All right, very good. I'll be there.
Yeah. I'll be there.
Don't think I made any headway with Mr. Greco.
Mr. People versus Lanto.
Your Honor, David Greco here on behalf of the City of Taylor.
And Mr. Lanto, your name for the record, please.
Well, I'm here in a conference room. Can I just come into the court?
If you'd like to, yeah, sure.
Okay, let's do this.
I'm bringing the recording up here.
Hello.
Morning. Good morning.
Morning. First, I'd like to recall the case of City of Taylor versus Joshua Lanto, case number 2022-22-2024-OM-OM. That case was dismissed without prejudice, which is against my wishes, and which is why I chose to speak for myself in the court of law today.
This judge's sigh says it all. Before the hearing even starts, you can feel the tension. The courtroom energy is off and it's about to get worse. The defendant, Joshua Lanto, believes he's legally untouchable.
So today is the date and time set for an arraignment and pretrial in this matter. First off, as to the arraignment, sir, you do have the right to remain silent. Anything you say can and will be used against you at trial. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the court of public expense. Do you understand those rights?
I understand the rights that you just told me.
All right. Sir, are you choosing, I do have a court-appointed attorney here. Are you choosing to represent yourself today?
I am choosing to speak for myself.
Well, let's just represent, speak.
I mean, in legally.
Tomato, tomato.
Yeah, no, you can't represent.
No, just at any point, if you do wish to have a court-appointed attorney, please let the court know so that I can effectuate that right in your wishes with regard to it.
I appreciate that.
Now, with regard to the alleged charges in this matter, it is alleged that with regard to the arraignment, do you wish me to read the complaint, or would you like to waive a formal reading?
If you'd like to read it into the record, I'd appreciate that.
Sure. Okay. All right. It is alleged.
Right here you can see the start of what's basically a sovereign citizen defense, where a defendant refuses to recognize the court's authority and insists on speaking as a free man. It's a classic move that instantly complicates everything.
For just a moment, because you did say, which is why I was trying to recall the matter of City versus Taylor versus Joshua Lanto in the previous case, because you said in that arraignment that I have the right to be informed of the cause and nature of the charges, correct?
Mm-hmm.
Okay, so obviously that case
Did you get a copy of the complaint? Are you talking about in this matter?
No. I haven't seen anything. As a matter of fact, I've requested discovery from your House counsel several times, and they have not given it to me.
But this case hasn't even started yet. This case is just getting arraignment.
Right. So the case.
It's not the arraignment stage. Right?
Yeah. So the case that I wanted to recall, because I had the right to be informed of the cause and nature of the charges in that case, but it's clear
that's not the case that's on my docket.
But that's why I wanted to recall that case, because this stems from the same incident. So it's almost like
saying recall as of. Because there's two different meanings of the word recall. Recall is to remember, or recall is to actually call that case.
I would actually like to call that case because it was dismissed without prejudice, and I wanted to be dismissed with prejudice. And I made it clear to House counsel that I had expenses when it came to that case.
Okay.
I think it's only fair.
So just from a procedural standpoint, it's not on the docket today. Due and timely notice wasn't given to the court nor to Mr. Greco about your desire to do anything with that case. So you need to motion that up for a motion.
But we are on record, right?
But we are on the record, and let the record reflect that I'm telling you that procedurally you need to, if you have anything you want to do with some other case that isn't the case that's set for this docket today, file a motion, file it with whoever you're going to serve obviously the other side, serve a copy on the court. The court will set it for a motion date.
Yeah, I appreciate that.
That case will be brought, and everybody will be knowingly and voluntarily present, and they will be given all the notice ahead of time.
Judge is trying to keep things procedural, but Joshua keeps derailing the process with side arguments and pseudo-legal jargon. You can feel the judge's patience thinning, but he's still trying to give the guy a fair hearing.
And one of those constitutional rights that you explained to me is that I have the right to be informed of the cause and nature of charges. And my point.
That's correct, and that's why I just told you that you were, the count one is alleged that you violated City Ordinance 32-31, commonly known with interfering with police authority. If you'd like me to read the expanded complaint, I can read the expanded complaint to you.
Well, may I just speak without being interrupted for a minute?
First off, I'm not interrupting you. Second, I'm just making sure that things are procedurally done correct. Third, I'm going to again advise you that anything you say can and will be used against you. You do have a right to remain silent.
I understand.
So if you choose to say anything.
Well, the reason I'm asking questions about the cause and the nature of the charges is because on the last case that got dismissed, it was clear.
You gotta stop referencing the last case because that's a separate case. Whatever happened with
We
that
have the
case,
same thing going on in
that
this
case.
We have a similar situation in this case, whereas I don't know if the prosecutor understands the cause and the nature of the charges because he had to dismiss the last case.
Yeah.
Right?
Well,
So how
I'm about to then let me read the complaint to you.
Okay.
Let me make sure you get a copy of the complaint.
Right. And I saw your YouTube channel I saw your video on YouTube.
First off, it's not my YouTube channel. It's something that's forced upon me that I'm required to do because there's a court order signed by my chief judge. I prefer to do all my cases in person, but I'm required to broadcast them.
At this point, it's not even about the charges. It's about control. Joshua wants the courtroom to revolve around his logic while the judge just wants. This is textbook courtroom chaos.
I get it. A lot of people watch a couple of things on YouTube or a couple of things on Google, and they think they become a legal scholar.
Well, let's be honest. They watch Law and Order, and then they think they're experts on the law.
I can't watch Law and Order.
Me neither. It's actually painful to watch that sort of stuff.
It's entertainment. That's exactly
It is. It's meant for entertainment.
It's not.
Right. On the last case that was here, though, I just have a few other clarifications.
Listen, again, I'm not going to discuss on the record any other cases that are no longer.
No. This isn't in regards to another case. This is in regards to my case and what happened.
This case right here.
Yeah, in this case, right? Yeah.
Again, before you start discussing the facts of this case, I am going to caution you that you have the right
Fifth
to
Amendment,
sign
yeah.
it.
I don't sign anything, so I'm just.
That's a copy of the. That's a copy of the.
Oh, okay, appreciate that. And now is there?
So now I'm going to read into the record what the allegations are.
Okay.
All right. So it is alleged that on November the 17th, 2022, that you violated City Ordinance, Chapter 32, Article 2, Section 32-31, interfering with police authority, which states, it shall be unlawful for any person within the city to resist any police officer, any member of the police department, or any person duly empowered with police authority while in the discharge or apparent discharge of their police authority duty, or in any way to interfere with or hinder the police officer or member of the police department in the discharge of the police.
This is an incredible moment. The judge mentions his YouTube stream, and you can tell Joshua's eyes light up. He's suddenly aware that he has an audience. That's when these sovereign citizen cases often turn theatrical.
You, the defendant, Mr. Lanto, engaged in a repeated course of conduct to interfere with Officer Andrew Borg's discharge of his authorized duties, which include traffic enforcement on South Telegraph Road near Ecorse Road in the city of Tampa. You, Mr. Lanto, allegedly had unlawful actions, including following Officer Borg on multiple traffic stops, approaching the traffic stops in the close proximity to Officer Borg and his vehicle and the drivers, yelling obscenities and insults at Officer Borg, and video recording Officer Borg while inside of his patrol vehicle while he was accessing protected lien information concerning the drivers that were pulled over. It's also alleged, Mr. Lanto, you were ultimately arrested after Officer David Jones witnessed you walking within close proximity to Officer Borg's vehicle during a traffic stop and attempting to video record Officer Borg while he was inside his patrol vehicle accessing lien information about the driver. In count one, more specifically, in count one, the violation of section 32-31, interfering with the police authority, you, Mr. Lanto, the defendant, allegedly approached the traffic stop at approximately 3:04 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol vehicle, and the pulled over driver.
The charges are serious. Repeated interference with police traffic stops. But Joshua treats it like a debate club. He's focusing on semantics, not facts.
A violation of section 32-31, interfering with a police officer, that you, the defendant, Mr. Lanto, allegedly approached a traffic stop at approximately 3:31 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol car, and the pulled over driver in a parking lot on South Telegraph Road, and attempting to video record Officer Borg while he was inside of his patrol vehicle, accessing leading information about the driver, and otherwise discharging his police authority. Again, those are misdemeanors punishable by 93 days in jail and up to $500 in fines. Those are the factual basis which gave rise to probable cause to execute this warrant, and now is being charged against you. Again, you have the right to remain silent. Again, you do have the right to have counsel at any given time. You're choosing today. As to those charges and the allegations, how do you plead? Guilty, not guilty, or you stand mute?
Well, I have to make a few clarifications before I make an informed.
This isn't a matter of clarifications. This is you either pleading guilty, not guilty, or standing mute.
Well, I was told I have the right to be informed of the cause and the nature of the charge. You just read this into the record, and all it did was confuse.
I did.
So, because we have right in here that Officer Borg, or I was told
Listen,
there was
I'm not-
close proximity of Officer Borg.
I'm not going to get
What
into
is
the
close
particulars.
proximity?
Listen, I'm not going to get into the particulars. This isn't the trial. This is nobody's sworn in under oath. There's subject to cross-examination by both sides. That's what trials are for.
Okay,
That's what trials are for.
before I make
This
an
is
informed.
just these things. So I'm going to give you 5 seconds to either choose guilty, not guilty, or just don't say anything. Or if you're not responsive, then I'll just enter a plea of not guilty so that your not guilty status is preserved and your constitutional rights preserved there as well.
Well,
So how do you plead? Guilty, not guilty?
I object for clarification.
Sure. Guilty or not guilty?
Well, I object to that because I can't make an informed plea today.
Fine. Then I'm going
Unless I have-
to enter a plea of not guilty on your behalf.
When he refuses to enter a plea, the judge has no choice but to enter a not guilty on his behalf. It's a legal safeguard, but Joshua takes it as another personal insult. This is where frustration peaks.
I have a feeling I need to inform you of a few things that pertain to the Georgia Police Department here, and I actually.
First off, if it has to do with the case, I can't take in anything from outside of the case. There's a reason that hearsay is not part of cases. Why? Because they're literally, by definition, an out-of-court statement being used to prove the truth of the matter asserted under Rule of Evidence 801.
Well, you've
That's
got
literally the
officers that
definition.
are lying.
So if you're,
Yeah.
So if you're telling me stuff right now, one, you're not under oath, so I could care less. Two, this isn't the trial.
Would you like to put me under oath?
No, I want to set this up for, if you want a trial, I want to give you a trial. That's what I'm
If
saying.
you want to see what happened.
And again, all of that would be done at a trial. If you're going to bring in evidence, it has to have foundations. You have to lay a foundation for every piece of evidence.
Well, then-
Evidence doesn't just come in. It has to be factually accurate and it has to be reliable.
Okay,
If they're
so
not both, that's how you lay a foundation for evidence. I have a scale in my garage. Every time I get on it, it says I weigh 187 pounds. I love that scale. Mwah. It's very reliable. Every time, 187. Mwah. Guess what? The scale's not accurate. It's reliable, but it's not accurate. All evidence has to, and that's what we do at trial. Today is just the day when I'm telling you, this is what you're facing. This is what they are alleging that you did. And if you'd like to set it for a trial, you can do so. If you'd like to have the assistance of an attorney, I'll make sure that you have an attorney present with you. Even if you just want them riding shotgun with you, so you can ask questions about the rules of evidence and things like that. I'm not sure what I don't know if you have.
well, that's the only reason I would ask for.
I don't know if you have a Juris Doctorate. I don't know what you know. I don't know what you studied. And I'm just telling you, that's why you have a right to assistance of counsel. If you'd like it at any time from now until the trial.
For administrative purposes only, but I will speak for myself in the court of law. I do not want anybody speaking for me.
Sure.
And they did that for me up in Pontiac. They gave me standby counsel.
Again, you're talking about some kind of case that I have nothing to do with.
I'm just wondering if
And trust me, while I appreciate it, I don't need any examples because I teach all this stuff. I know exactly every example.
So, and I'm pretty sure you know what Houston v. Still says about police interference.
So, again, if you want an attorney, I'm going to let you have an attorney. If you don't want an attorney, you want to speak for yourself and represent yourself, you have a God-given constitutional right to
Because
represent
Houston v. Still says that police interference is physical.
I'm not going to get into a civil procedure class here.
All right.
I have other cases to do. You've been advised in the premises of what the charges are against you. I'm finding you're unresponsive as to guilty or not guilty, so I am going to put in a plea of not guilty.
And I have to object to that on the record.
Sure, it's on the record. And now, if you don't want to speak with Mr. Greco at this time, then you're more than welcome to leave, and you'll be given a notice as to moving forward. I can set this up for a settlement conference, or we can just set it directly for a trial.
Okay, and then the next time we're here, we'll be able to recall the old matter, so I can get
I can't answer that question because that may be me giving you legal advice.
Okay.
When I'm wearing
I think
this
Mr. Greco should
robe,
be on the hook.
it's like being a referee. I can throw a flag, blow a whistle, but I can't coach either team.
Yeah.
I can't tell you how to proceed or what manner you should proceed.
Well, you spent about a half hour explaining it to somebody else.
No, I explained to them.
Well, it was a formal motion.
I wasn't giving them legal advice. I was merely explaining what jurisdiction means. They had already said in their motion, they had filed a motion.
Right.
Stating each individual
watched
reason.
it. Yeah, I watched it. I pay attention. I'm actually here to look for areas we can find agreement.
Say again, I'm sorry?
I'm actually here to look for areas we can find agreement.
Oh, well, then that's someone you need to talk to Mr. Greco about.
Well, I don't think he's going to find agreement.
You're not going to find, with me,
He's going to have to litigate.
with me, agreement comes from because the two parties approach me with an agreeable situation that they want to put on the record, in the form of a plea or a dismissal, or I can do a trial and I let the facts that are all under oath speak for themselves.
Well, and when I saw the mob boss judge, he actually had a different case, and he was actually a lot more fair than I originally gave him credit for. So the mob boss judge, I'm glad he's not here, but he's the one that he's the one that told me I would be assigned an army.
Well, first off, I don't find I find it disrespectful to refer to somebody as a mob boss. That's because that literally is,
that's how it felt to me.
Well, what I'm saying is you just libeled somebody.
Well, that's how it felt to me.
Because now you put him in what's known as false light. And I'm just telling you, I wouldn't do that.
Well, I appreciate
For civil reasons alone, I wouldn't do that.
I appreciate the one.
And I'm not going to allow any sort of disrespect to the judiciary, especially when I didn't watch over it, and especially because the Judicial Tenure Commission, they've sanctioned the action, and sure, I have no problem with making commentary about it. Until that's been done, there's no need for doing that.
Yeah,
and trust me, you're not going to garner any favor, nor are you going to do anything but lose respect for me if you're just going to throw like petty comments in there like that. I prefer people who just let the facts speak for themselves and let the law speak for them, and they just keep it professional.
Okay, well, as long as we're just here to put facts on the table, I can do that.
Sure. Then you've been advised, and so you're either free to go or free to talk to Mr. Greco further.
All right. I mean, if he wants to talk to me, we can talk.
All right, I can always.
The judge finally breaks it down with authority. He explains the law, evidence, and procedure in simple terms and shuts down every sovereign argument. Calm, precise, and absolutely devastating. Music,